This is Legal Live with Eddie and Chuck Farah. They're talking the latest legal news and answering your questions. To call Legal Live and ask Eddie and Chuck a question, grab your phone and dial 855-765-1045. That's 855-765-1045.
Welcome. You're listening to Legal Live, brought to you by Farah and Farah on 104.5 WOKV, Jacksonville's News and Talk. I'm your host, Sheifalika, and I'm joined today by Lloyd Manukian from Farah and Farah, as well as Matt Hinson with his own law firm. We would love to hear from you guys. Today we're going to be discussing some probate and estate planning law. Give us a call at 855-765-1045. How's your Saturday going, gentlemen?
It is going fantastic. You know, we had so much fun last week that it's like, oh, man, we have to come back. We have to do this.
That's awesome. I'm so glad you guys are back, coming back for a second weekend in a row.
Yeah, it's like a solid, 10 degrees cooler today.
It's not the surface of the sun. It's just super hot.
It's really weird where, like, the Northeast Florida is, like, the coolest part of the whole country, and that's a little scary right now.
That is terrifying.
Mm-hmm.
Wow.
Yeah.
Wow. Well, let's jump right in. We've got some cool issues to discuss. You guys are experts in, estate planning, probate planning, stuff like that. Explain to our listeners what some of that means.
Well, that would be Matt, actually. But, all right, yeah, let's talk about it. It's a great topic. We started going on it. We had a couple good questions last week, and there's so much to cover. So in the personal injury field, we use it, as I said last week, where, someone dies and we have to open up an estate. But there's so much more to it than just that. Some of it as well goes to protecting yourself, protecting your personal assets, and protecting what you leave behind for your kids or whomever. Okay, and that's where we use Matt in a lot of these things, and that is his specialty area. And so I figured this would be a great opportunity to talk about, like what a trust is and how it relates to protecting people. So, for example, if I rear-end you and you decide, all right, you want to make a claim against me and you sue me for, $2 million, well, bollocks, how do I protect myself here? I only have $100,000.
Did you say bollocks?
I love that. Let him go. Keep going.
Yes, I did.
I love that.
How do I protect myself there?
Good question.
That's where sometimes something like a trust can be used. I mean, Matt, you want to talk about that a little bit?
Sure. And, I will say that in general, probate law and estate planning and trust law, it's not something we all sit around our dinner table and talk about. And so it's really important to understand at a fundamental basis just some of the words that we use and some of the terminology. I'll give you an example of why this is important. Very short, quick story. A lot of people don't know this. Lloyd, you know this. I used to be a police officer. And at one point in my career, I had a guy that I arrested. We'll call him John Doe to protect the guilty. And John was arrested on some warrants. He was well known to us. He'd shot at us, and not a nice guy. And so John had some warrants, and we're in the booking room. Now, you can imagine if you're sitting in this booking room, okay, it's kind of hot, smelly. If you got other people being arrested, nobody's in a good mood. Everyone's in a poor mood. So I'm reading these warrants to John, and the first warrant, yeah, I did that. Second warrant, yeah, I did that too. We get to the third warrant, and the third warrant was for assault and battery. So I start to read it to him, and he stops. It stops the whole room. Everybody gets quiet. He says, man, I didn't do that. I didn't hit that beep with no battery. I hit her with my fist.
Oh.
And so the whole room erupts in laughter, and hopefully at home you're probably erupting in laughter right now. But he didn't understand what battery meant, and it's at a very fundamental level. Mm-hmm. People don't understand the information and the terminology we use in probate. So I think it's important to start just generally about probate and what it is and what it does.
Right,
so
let's start there.
So probate is an area of law, and it's a division of the court system, that the purpose of it is to transfer assets that are subject to probate to the individuals or the creditors that are supposed to receive it. So that's the general basis. Now, the assets that are subject to probate is a big question. In general, it's something that's subject to probate is an asset that's owned solely in your name.
I see.
Without a contractual beneficiary name to it. For example, a bank account that has a beneficiary name to it has a contractual beneficiary, therefore it's not a part of probate. So then the next question is, well, what does a will do? Mm-hmm. A will tells a probate judge what to do with your assets that are subject to probate. So a will does not control all of your assets, just those assets that are subject to probate.
I see. Okay.
A trust then comes in, and the trust purpose is to avoid probate, because if you title all of your assets in a trust, then that trust that means your assets are not titled in your name, they're titled into the trust. Think of the trust as kind of like a business. And so that business is going to be the owner of those assets instead of yourself, therefore you skip probate. That's kind of the general terminology of probate versus trust and how it works.
I see. That's really fascinating. I think that that's such a big issue, especially for here in Florida, where a lot of people come to retire and a lot of young families are looking to their parents to help them get set up for their future.
Yeah, I have a lot of friends over the years that have come to me and said, oh, I just lost my dad, and, he's got his house, and, okay, yeah, there's me and my brother, but there's no will necessarily. Well, what do? It has to go through probate.
Right.
Okay?
I see.
And the trust can help bypass that. You don't have to go to the courts, file with the probate courts, get a judge, get a personal representative appointed. You don't have to go through all of that process. You can handle it through the creation of a trust.
Wow. Okay. Well, where are some easy places for people to start? Like if they have questions, is there like an online resource for this kind of thing, or is there some information they can get from the courts?
It probably depends on who you ask. If you ask any attorney, you'd never want to try to do any type of estate planning or trust work on your own, because every state is unique in their laws. The state of Florida has unique laws that are different than the state of Georgia or Alabama or any other state in the union.
Really?
And so you want to focus specifically on where you live, number one, and then two, the type of trust. There are so many different types of trusts, so many. Irrevocable, revocable, land trust, gun trust. There's tons of different types, testamentary trusts. There's tons of different types of trusts. That's why you need to consult with an attorney about what you need. And sometimes you may not need a trust. You may think that you need one and you don't. And so that's why it's so important. Just take the time to just a basic consultation to understand what you need. That's going to help you, because Lloyd and I were talking before the show today about some of the protections of trust and the concern of, well, if I get sued because I'm in a car accident and it's my fault, does a trust help me? It depends on the type of trust you have and the language of that trust. And it can be helpful, and sometimes it cannot be helpful.
That's really interesting. That's something I would love to dial into a little bit further into the show, because there are so many different kinds that I've never even heard of, what you just mentioned. So that's pretty cool. And we are, of course, taking your calls as the show continues. We are, welcoming you to give us a call. We had a lot of great callers last week. There is another celebrity issue with the will I'd like to discuss coming back in after this break. You're listening to Legal Live, brought to you by Farah Farah on 104.5 WOKV, Jacksonville's News and Talk. Our number is 855-765-1045. We'll be right back after this quick break. Welcome back. You're listening to Legal Live, brought to you by Farah Farah on 104.5 WOKV, Jacksonville's News and Talk. We're here for all of your calls, and in fact, we've got a caller on the line. Give us a call, though, if you have questions, 855-765-1045. I'm Sheifalika, and I'm joined by Lloyd and Matt. Let's go straight into the call, guys. What do you think?
Let's go for it.
Let's do it.
Let's do this. We've got Richard from Jacksonville, and you've got a real estate-related question. What's going on, Richard?
Yeah, some time ago we set up did a new will or last statement or whatever you want to call it, and we were advised to put our real estate into a trust, personal real estate and investment real estate. Prior to that, the real estate was the investment property was just in my name. If we go to sell one of those investment properties now, will both of us be involved in the contract as far as signatures and all now, or is it still revert to me?
That's a great question. And once your property is in a trust, in order to convey property out of the trust, it's actually the trustee of the trust who's going to be responsible for signing off on it. Now, sometimes title companies, especially when it involves real property, whether it's investment or a homestead, title companies are going to want the signature of all of the beneficiaries of the trust, as well as maybe a spouse or anyone else that would have homestead interest if it's a homestead property. But generally, it's going to be the trustee over the trust, or if there's multiple trustees, the trustees that will be the ones conveying the property and signing the documents for closing.
So if we establish an offspring as the trustee, then that they, as opposed to us, are going to sign on the contract?
If your offspring is the current trustee, now there's a difference between being the current trustee when you set this trust up versus the successor trustee. The successor trustee is a person that comes in for the original trustee. So if you've established yourself as the trustee, it would be you. If you've established an offspring or an heir as the trustee, yes, they're the individuals that will need to sign off on it.
Okay, very good. That's what I need to hear then. I thank you very much.
No problem. Have a great day. Stay cool.
Thank you so much for calling, Richard. That was a great question.
Right on point, yeah.
Exactly. That was exactly on the point we were discussing: probates, trusts, estate planning. There's so many terms out there that, like I mentioned just before the break, I didn't even understand. So, Matt, if you would do us a kindness and just maybe loosely define some of these terms so that it's a little more clear for people like me and our listeners.
Sure. Excuse me.
Yeah, are you okay?
I'm good.
Stat, we need medical service in the live studio.
You got me nervous. No. So there's a couple of terms we use in probate. We'll talk about the probate world first. Personal representative, also known as executor, depending on which state you're in. Mm-hmm. But personal representative is the person that's going to be tasked with being over the estate when you pass away and over your estate assets. A judge is going to have to appoint that person. The beneficiaries of the estate are someone that either by statute or by will, if you have a will, are going to be the individuals who are to benefit from your estate after creditors get paid. Boom. Nice. Creditors. What's the next thing we need to define? Creditors. A creditor is anyone who makes a claim against your estate that is a valid claim that states that they were owed money by you at the time you died to them. And so that creditor gets paid in a series of priorities first before any money gets distributed from the estate. So those are some basic probate terms. As it comes to trusts, trustee. The trustee is the person who is essentially the owner of the trust property. They're the ones that have the power over it. The powers that they have over that property are going to be granted in the trust document. The person who begins the trust, or the settler of the trust, that's oftentimes the person who's putting their property into a trust. That is going to be the one that begins it. So the settler and the trustee oftentimes are the same person when you're starting a trust. And then likewise, beneficiaries of the trust, whether it's a current beneficiary or a future beneficiary, it's the same definition as what we have in probate world, with it's someone that's going to benefit from it. And then obviously we have tons of different types of trusts that we kind of mentioned.
That's right. And so Florida laws are something that may be unique from other neighboring states. Are there any examples like that you could describe for us as far as estate planning and probate law goes? How is Florida different?
Florida's different in our homestead laws. Your homestead is the property that you live in, that's your domicile at the time that you pass away. Those properties are protected for your heirs against other creditors, except for any creditors that would be attached to the property itself. So a credit card company couldn't come in and force the sale of your house to satisfy a debt when you pass away if that house is your homestead. The only individuals that could force that sale would be the mortgage company or mechanics lien.
Like
exactly.
If you have a contractor that does work on your house and you don't pay them, and if you don't pay them at all, eventually they can essentially force the sale of the house to satisfy that. It's what they call mechanics liens. But otherwise, homestead really does provide a lot of protections for a person.
Wow, that's really incredible. I like the homestead law. It seems to sound like it's good for the heirs and the offspring of.
It is. I mean, if you live in your home, let's say, and you have a $50,000 credit card bill and you just default on it and you get a judgment against you, they can't kick you out of the house. Now, if you sell the house, they can still put a lien against that and take some of the money before you get it from the sale proceeds.
I see.
But they can't kick you out of the house.
Gotcha. Well, that is an important distinction, I believe. I mean, I think that's really interesting.
And if, again, you still have that, debt that you owe, having, your assets in home, again, can be protected, either through probate or there's certain creditor procedures that have to be followed, or through a trust that can provide additional protections.
Pay attention when you see celebrities move to Florida.
Oh, really?
So ever so often, you'll notice that a celebrity is moving to Florida and moving all their assets to Florida because perhaps they may have had a judgment against them in another state. I don't want to name any famous ones specific, but there have been some that have had massive judgments against them that have moved to Florida, put all their money in their homestead to protect it from judgment.
Wow, that's interesting. I just thought they liked the beaches. I guess not. They're trying to protect themselves.
Wave and smile at your neighbor, but always just think, I wonder why.
I wonder why. You know, during the pandemic, we did see a lot of people moving from states where there was a lot of rich residents, you know, New York and, you know, Colorado, California, a lot of people moving here. And at that time, Florida seemed to have, you know, a booming house like market, and there was just a lot of availability here for people to come in and resettle.
Absolutely.
I'm wondering if that may have been part of the reason as well.
Well, Florida has no income tax. Florida has great homestead laws. There's a lot of reasons why people move to Florida.
Right.
I'm joking when you say question your neighbor, but there have been cases of celebrities that have moved here. I don't want to name, again, specific ones, but there's been those cases that it's been pretty obvious why they're moving.
Yeah.
But, yeah.
Well, that's interesting. Well, we do have a celebrity issue that I'd like to discuss coming back after this break. I think that I'd like to learn more a little bit about the Aretha Franklin issue. Is that something you guys would like to discuss coming up?
Absolutely. Yeah.
Okay, fantastic. Well, we do have a quick break coming right up. You're listening to Legal Live, brought to you by Farah Farah on 104.5 WOKV, Jacksonville's News and Talk. We'd love to hear more of your questions. Give us a call at 855-765-1045. We'll be right back after this quick break. Welcome back. You're listening to Legal Live, brought to you by Farah and Farah on 104.5 WOKV, Jacksonville's News and Talk. Feel free to give us a call. Our number is 855-765-1045. I'm Sheifalika, and I'm joined by Lloyd and Matt here to discuss issues regarding probate and estate planning. But we do have a caller on the line, gentlemen. Let's jump right into that. Sound good?
Let's do it.
Let's do it. All right. Jane, you've got a issue with hiring a contractor that apparently damaged your home while they were working. What's going on, Jane?
It's been a year now, and I wrote the roofing company 3 emails. I sent certified letters with them, and she answered the first one, was very apologetic, and never answered any of the other 2 emails. I've never heard from her again. What happened was they were removing the chimney off the roof of my house. When they were taking it off, they knocked off my vent stack pipe. When they did that, they boarded over it and roofed over it. It was like within 2 days they did everything, and my toilet started gurgling. I didn't know what was going on. I got on YouTube. Anyway, I called them. They came out, and they said, oh, well, all the gases can go up through the vent. No problem. I said, no, that's the reason there's a vent stack pipe. And the long and the short of it is I went for over 5 weeks without a toilet. I have a 1-bathroom house, and they never took care of me. This was elder abuse. I called 2 different plumbers. They had to get the camera down. I spent over $2,000 with plumbing. They messed for them to fix that. They got the camera down. They saw it was their problem. They would not own up to it. I sent them photographs. I sent them the information, you know, the billing. They messed up my leaf filter gutters. When they took those off, they didn't even tell me. They just went ahead and did it, and they were all crumbled up and messed up when they put those back. They got ruts in the front yard when they brought up the shingles because it had been raining. And then he had the audacity to say, well, would you rather me charge you $300 for them to carry them up? Or in other words, you want ruts or, you know, this or that. So, but I don't know what to do. I mean, I wrote her. I sent certified letters. Like I said, and they never even sent anybody else to look at it. She said that she wanted to, and the one day that she said she could do it, I wasn't available. I had a doctor's appointment, so I asked her to give me another date, but I never heard from her again.
Well, if I could ask you a question. Ultimately, was these damages, were they actually repaired? Did you actually pay someone else to fix the problem?
Yes, I did. Yes, I did, sir.
Okay.
Yes, I paid two plumbers. I I had the roof filter gutters come out. I mean, leaf filter gutters come out and do it. They said it messed up my warranty. They went back. I had to pay them. But the main thing was the other, and they even sent a GM out there to look at it and said that he'd have to go through the walls. I had to order a new toilet in case he broke my toilet. Then I had to send that back.
Jane, what I would like to do, because in case like this, if you already paid for it, you do have the ability to perhaps even file in small claims court, because it's less than, I think they just changed, they upped it to like 10 or 15 or 25. 25, I think they upped it. It used to be like 5. It was very low, but they've upped it where you actually could go yourself and file in small claims court against them, because to get an attorney may be expensive. Now, we can, if you want to hold on, we can get it from, get your number, and we can give you the number of the Jacks Bar Association as well. But I think that might be a good solution.
The thing is, I have not paid the company anything. I have not paid the roofer anything because she never got back to me. It's been a year. I don't know if she's going to put a lien on my house or sue me.
If they never finish the job, they really probably, you could
they
contest
finished
anything.
The job.
Right?
They did finish the job.
But if
The job is finished. I have the roof, but the thing is, I had to pay to have the vents put up, to have the vent pipe fixed by a plumber, and they had to get a camera down there to see what was going on.
If they created additional damages, you could file in small claims court. But my recommendation would be, we can get you the number for if you want to hang on, we can get you the number for the Jacks Bar Association, and someone who maybe specializes in that kind of construction law.
Yeah, I think that also we should grab your number, Jane, from our producer, Daniel, so that maybe we can have a member of Fair and Fair give you a call specifically, as well as if you are interested in the Jacks Bar Association, they can speak to you for like half an hour, get your story, figure out what the right expert attorney would be for your case. And then that way, they can get you the right referral. If you have something to write this down with, their number is 904-399-4486. But if you'd like, Jane, I think it'd be a great idea to stay on the line a little bit, and our producer, Daniel, can grab your number. It seems like there's so many moving parts to your story. And since it's been going on for a year, I'm sure it's very frustrating. And
I don't want them to sue me or come back and put a lien on my house. But the question is, too, at this time, it's been a year. Can they do that?
Can they actually come after her?
In theory, they could. It certainly would be something is disputed, and they don't automatically get it. They have to prove the validity of the claim. And if they've caused more damages, it's almost a countersuit. It becomes a countersuit at that point.
I think that you do have a defensible case should they ever try to come after you, but the fact that they probably realize post-fact that they damaged or caused extra problems that you had to pay out-of-pocket extra for from some other specialist, that would really make their case kind of weak, don't you think?
Absolutely.
Yeah. So
the thing is, I haven't paid them anything for the roof. I have paid them nothing because they never got back with me on that. And then their guy that oversaw everything just called me a few weeks ago and said, it's been a year, when are you going to pay? And I even told her I didn't want to deal with him anymore because he was so rude to me. And he's calling me, trying to get money from me after a year. And I told him I had written her 3 times. I sent certified letters. She answered the first one and never answered anything after that.
I see. Okay, so there is somebody reaching out. Well, I think that the best situation here is to find an attorney that can advise you specifically how to respond appropriately to anybody reaching out regarding this issue. So stay on the line real quick. We're going to get your phone number. Daniel, I just gave him a little signal there to grab your number for us, and we will send your information over to the Fair and Fair law firm. We'll see if you can find somebody just for you, because it's important to know how to respond appropriately and protect yourself, right?
Yes, and what is your name?
My name is Sheifalika.
Oh, what a pretty name.
Oh, thank you. Thank you so much, Jane. I appreciate that.
Thank you for the call, Jane.
And thank you for calling. We're going to find you some help here. Stay on the line for just a quick minute. We do have one other caller on the line. We've got 2 extra callers. Wow, look at that. So Holly from Callahan, let's see. Tell us about your relatives whose son may be putting their estate at risk. What's going on?
My question is, I have a couple of relatives. I'm not going to name any names because they might be listening. One is an elderly woman who just happens to be my mom, and she is 90. And then we have a relative that moved in with her that kind of needs a helping hand right now because he's going through a rough patch. And my concern is my mom is letting him drive her car. And a little over a year ago, he had a DUI. Now, he swears he's gotten his license back and that he has insurance, but I don't know what all the rules with that are. I don't know how you get insurance if you don't have a car. And I told my mom she needed to go down and have her agent add him physically to the policy, not just, oh, it's okay if my son drives my car. And I tried to explain to her that if he had a wreck while driving a vehicle that's in her name and paid for, that they will not only sue her and come after her assets, but her house is paid for and in her name. What can we do to protect her?
Well, actually, Matt, why don't you said?
Yeah.
Well, let me ask you a quick question: Is the son? Or do they live together?
Yes, they are now temporarily.
When you say temporarily, you're talking like for
yeah,
a week
he lost
or two?
his house. He's
okay for a period of time. So if he's in the household, I would tell you best bet is to get him on contact the insurance agent, and you are correct in that regard. Get him on the policy. Now, if they weren't living together, you don't really need it on the policy.
yeah, but he's moved into one of her bedrooms.
Yeah. Well, and another concern that you're going to have here, and this I'm going to speak broadly because if there is anyone listening, I don't want to give any specific advice to you, but in general, when folks get older, there's a question of capacity. And if they have the capacity to make decisions for themselves, then it's really going to be up to them. And when I say capacity, I mean the mental and physical ability to make decisions for themselves. And so if they do, the law allows people to make bad decisions for themselves. If they don't have capacity, that's when the court process would get involved regarding guardianship, or if the individual has a power of attorney, whoever is named as their power of attorney will likely be the one to make decisions for them, assuming that power of attorney is valid. So
yeah, my greatest concern is an accident, and then somebody tries to take away the one asset she's got that's great, and that's a paid-for home.
Well, as I said before, yes, if it's her car, and her son is driving it, or someone else, anyone is driving it, yes, she can, as the owner of the car, will be sued. Okay, potentially, and the insurance company will provide coverage up to a certain amount.
Right.
But yeah,
Thank
again,
you very much.
we can get your number if you have some additional follow-up questions on that as well.
Okay. Well, thanks. Y'all have a great day.
Thank you so much
You as
for
well.
calling, Holly. I really appreciate that. We've got some really great questions so far today. You're listening to Legal Live, brought to you by Farah and Farah on 104.5 WOKV. Feel free to give us a call. We've got a few minutes left of our lovely show today. Our number is 855-765-1045. We do have some more callers on the line, so when we get back, we're going to come right to you. Hang in there. And I really want to discuss this really interesting celebrity case involving a will that's happened recently. All right, we'll be right back after this quick break. Welcome back. You're listening to Legal Live, brought to you by Farah and Farah on 104.5 WOKV, Jacksonville's News and Talk. I'm Sheifalika, and I'm joined today by Lloyd and Matt. We have two guest attorneys here discussing a lot of issues and a couple of callers on the line and just a few minutes left. So let's jump right in. We've got Dawn from Jacksonville, and you've got a question about trusts. What's your question, Dawn?
Good afternoon. My question is, can you have co-trustees on a will, or
Don, I think you broke out a little bit there, but it sounds like your question is whether or not you can have co-trustees of your trust, and the answer to that is yes, you absolutely can.
Okay. I'm trying to figure a way to do this. I was a trustee to my parents' will, and despite best actions I could, everybody's mad at me. It seems to be the thing that happens to trustees. So I thought with my two children, maybe if they could be co-trustees and co-beneficiaries, maybe they could work it out themselves or go to a third party.
Yeah,
They have to.
Yeah, those circumstances are often frustrating when you get into probate or trust work. Of the person in charge can sometimes be the the villain of the group. But you can certainly make co-trustees. You can talk to them beforehand and try to make sure they understand what they need to do and what your wishes are. Even if it's not in writing, at least make sure that you're expressing that you want them to get along and not fight. But you absolutely can do that.
Yeah, the money, when it comes down to money, everybody gets along.
Oh yeah.
Before that. So.
Oh, yeah. Great question,
Okay,
but the answer is absolutely.
All righty, thank you.
Thanks, John.
Thanks for calling in. Let's go to Thomas from Arlington, and you've got a question about savings accounts. What's going on, Thomas?
I have a savings account and a checking account. I'm single. I have one child, but I've listed my fiancé as the beneficiary on both of those accounts. The savings account is quite substantial, and the checking account is pretty good. Do I need a will, or will anybody be able to interfere with her getting that money when I pass?
Yeah, if it's on the beneficiary, you show up, someone shows up with the death certificate, they're just going to process it towards that beneficiary. That's
okay, so I don't have to worry about anybody trying to take that money from my fiancé then?
People can certainly dispute beneficiary designations, but that costs money. Once they find out how much money it costs to challenge those things, a lot of times they back away.
Okay.
But there's in our world in our society, people can sue anyone for anything at any time, but it doesn't mean they're going to be successful. So
right.
You can only do the best that you can do to plan your estate as best you can by naming these beneficiaries, and you have to leave the rest up to the court system and people doing the right thing.
Okay, and I thank you very much for your time, and you've answered my question wonderfully, and thank you all for your service, and God bless you all. Have a good day.
Thank you for the call.
Same to you, Thomas.
Thomas, that was amazing. Thank you so much for calling in. And I think that Thomas's question led into an interesting question that I have. What makes a will valid? We've got a couple of minutes left, and I would like maybe you guys to dive into some of the issues that we've heard about regarding some celebrity cases regarding a will and what's real and what's not.
It's amazing in our society, as much as we talk about the need for estate planning and wills and trust and things, that most people are not prepared, and that includes people with lots of money. I think one of the most famous ones that we've seen lately is the Aretha Franklin case. It's up in Michigan. She passed away in 2018, but they found 2 different wills in her house, none of which were done apparently by attorneys. One was found in a cabinet. It was dated 2010. The other was found in the couch cushions in a notebook, 2014. And after years of litigation, the family has got an answer that the 2014 will has been admitted to probate after a jury trial up there. And the question of which will was valid comes down to a lot of answers. And so some basics of what makes a will valid. First, it's got to be signed by what we call the testator. That's the individual who's making the will. Second, it's got to be signed by the testator and 2 witnesses, all in each other's presence. So everybody needs to be together. 2 witnesses and the testator all signing at the same time, seeing each other sign. And there's some other things that you can do called a self-proving affidavit, which includes a notary, but the bare minimum, signed by the testator and 2 witnesses, all in the presence of each other, all at the same time, properly dated, no blanks on the will. You don't want to have anything that could later be filled in handwriting and create a challenge to the will.
And I would remind you that different states have different laws as to what makes a will valid. So what works here in Florida may not work in another state.
I see.
Yeah.
So is there like a universal will?
No.
No? What?
No.
We need to invent that then.
Every state has their own requirements, as Lloyd mentioned. Every state has their own requirements and their own obligations. And, this will in Michigan, I believe, the 2014 will that was found in the couch cushions was only signed by Aretha and 1 witness. But that was valid in Michigan. That would not be valid here.
And copies of wills are, depending on the state, not necessarily valid either.
Wow. So when you're writing up a will, and perhaps you do live in Florida, you plan to retire here and spend the rest of your days here by the beach, but you have estates across the country, do you need to look at those individual states to see how to leave those properties or those assets to your beneficiaries, or do you need to just say, I'm in Florida, I want my Michigan house or my Hawaii summer home to go to blah, blah, blah?
You definitely want to look state by state, because when it comes to, especially if you have real property, real property and how you have it titled in your name will depend on how it's going to be transferred. For instance, in Florida, if you have property titled husband and wife, if the husband passes away, the wife will get it.
Okay.
In Texas, my understanding, now I'm not barred in Texas, so this is just my understanding of talking to other folks that are friends in Texas. In that same scenario, it's called a community property state. It would be still owned 50-50. So if the
Oh,
husband passed,
okay.
then the wife would still only own 50%.
I see. All right. Well, thank you guys so much for coming in. We've had Lloyd Manukian.
Manukian.
I'm going to get it one of these days. If I can learn my name, I can learn yours.
Right.
And we have Matt Hinson. I just want to say thank you again to all of our callers, Richard, Jane, Holly, Dawn, and Thomas. You guys were lovely, and your questions are really helping educate the rest of us out here. People like me haven't even thought about estate planning, and the rest of our listeners. Thank you so much for listening in to Legal Live, brought to you by Farah and Farah on 104.5 WOKV, Jacksonville's News and Talk. Feel free to call in next Saturday. We'll be back again at noon. Thank you so much for listening.